On the left, yeah.
On the left?
Yeah.
Just put the door.
Just behind it.
Okay, right.
There you go.
Eventually. Just,
Yeah.
Stuart. Cheers. That is some serious. That's some serious assistance there. Very perfect.
Hot rice.
Smelling it. My lords, I hope I can.
In the matter of the appeal part heard, Sky Ltd, formerly Sky PLC and others, and Skykick UK Ltd and another.
Smelling it. My lords, I hope I can quickly just hand up a roadmap. It's a half a side of A4. My own friends. Headings, not submissions. My lords, what I propose to do is to spend about 30 to 45 minutes just going through all of the issues in the case, going through all of these points, giving you, I hope, a nutshell position of Skykick on each of these issues. Then I propose to develop infringement and validity in a little more detail, really by reference to authority in some of the papers, and respond to my learned friend's points from yesterday. You will see from that that I propose to start with infringement, and in particular looking at electronic mail services in Class 38, computer services for accessing, retrieving, etc., and the other selected goods and services. The reason, of course, I start with electronic mail services is that I've got to deal with them one way or another. They're not touched by the bad faith issue at this stage. The judge found that Skykick infringed Sky's trademark insofar as it covered email services, and only insofar as that concerned the migration service provided by my client. We will say he was wrong as a matter of construction, or put another, perhaps more straightforward way, the data migration service is not an email service. You don't use a migration service or product to send or receive emails. Secondly, if the court takes the view that the judge's redrafting was appropriate as regards computer services, I would be left with another term which the judge says would be infringed, namely computer services for accessing or retrieving audiovisual or audiovisual content documents via a computer or computer network. I'm going to abbreviate that as I go to computer services, save as necessary. We say again, wrong as a matter of construction. You don't come to Skykick looking for a way to access and retrieve online audiovisual or audiovisual content and documents. A consumer, a business, would not think of us as that. This was alleged to have been infringed, found to have been infringed by the judge in relation to the Skykick cloud backup service. The clue is in the name. We're a backup service. It might be said that the construction issues in this case simply stop there. We just don't do what's in their marks. It's as simple as that. But if we go further, it just gets clearer and clearer We just don't do those things. The judge went wrong on email services for a number of reasons. Errors of principle, errors of approach. Because he wrongly gave, firstly, the word services a significance it should not bear. All the things in classes 35 to 45 are services already. You can't then give the word services significance. Just as the classes 1 to 34 are goods. And not only did he think that word to be important, but it allowed him to construe email services very broadly indeed. Services of or related to X. Email services in this case. Now this goes against a number of clear interpretive principles about the construction of trademark specifications. It imports words into the text, which are not there. It's of practically infinite scope. Any service might be said to relate to email services on that basis. We even see my learned friend's reply skeleton talking about the fact that our product spits out an email to a client, and that's said to be an email service. In the same way that if my car's ready for collection at the garage, they send me an email. It's a garage service. It also does not identify the service in question. It's just defined relationally. It's really any service related to email. And finally, the words related to have been specifically blacklisted by the trademark officers of Europe in a joint initiative. They're unsuitable, and yet that's the way the judge interpreted it. So that's how he interpreted email and its brother term, telecommunications, of or related to telecommunications in the third judgment. They stand or fall together. They were both said to carry with them a multitude of unidentified other services that could presumably cover almost anything in its scope. As regards telecommunications specifically, the judge held this, that in relation to email services, obviously it doesn't add anything. That's in the third judgment. And then insofar as it covers non-email telecommunications, Sky's case was weaker. So if email goes, all the others got to go too, for the same reasons. Now, given the tenuousness of email services, one is left asking why on earth computer services for access, etc., computer whatsits, came in right at the death at the form of order hearing and on an identicality basis or highly similar basis, given the judge's findings. Now, we say for both terms, he wrongly failed to take account of the class number. Now, I anticipate there's going to be a little bit of controversy about this, but I hope I can avoid it by saying this. We do not suggest that class number is the key index to the meaning of terms in trademarks. Many terms are clear on their face without reference to class number. So, for example, email services. You want to know what that is, or email. You don't need the class number. It's confirmatory. You know it's a message sending and receiving service, like all the other things in class 38. Signaling, a communication service. But nor is it right to go as far as my learned friend would say, which is you must positively exclude it. You must airbrush it out as if it is not there, it's not permissible. We say that's going too far.
So it's not an envelope which constrains everything within the list of services.
It's an aid to interpretation. There may be cases, for example, where there's a conflict between the meaning given by the express words and the meaning given by the class. That's not this case.
It's not uncommon to find things in the list which don't actually fall within the literal meaning of
Also,
the class heading.
exactly, and that's the point I wanted to come to.
So it's can't be a reliable canon of construction to say that this must mean X, because otherwise it would fall outside the class heading.
It all depends on the term and on the case. In the case of Altechnic, which I'll come to, valves could be fitted a number of different classes. If you put them in one class, they meant baby bottle valves. If you put them in another class, they could be engine valves, completely different commercial products. And in that case, it was quite a helpful thing to know what class you were talking about. In other cases, it might be misleading. It might be, as we saw with the IP translator controversy, where the class heading covers all. But we say it is to be taken into it isn't to be airbrushed out. It can be an aid to construction, and it's part of the information chosen by the applicant when it applies for the mark. And so therefore, it's part of the information the public see. It's part of the information the registrar, the registry office uses, and it's used by other traders to determine what on earth's been registered here in relation to that sign. Now we say both email and computer services are in the telecommunications class. That gives colour to their meaning. Certainly email doesn't need it, but the computer services talking about access and retrieving effectively media, they're in the telecommunications class. And so they're concerned with communication at distance of something, some sort of communication service of media. Now, a migration service migrates. Core purpose is to transport the data settings, the environment of one office or a number of users to another. That's not an email service. And a backup service, well, we know what that is. Safe and secure holding of data in case of emergency. A backup service backs up. It silently whirs away in the background, backing up wholesale. That's what our product does, in particular Office 365 programs. Now, as in all trademarks language, it might be fuzzy or unclear at the edges, but it's pretty clear what it does. It must do. It's a backup service, and that core feature is absent from the words in the computer services mark. Trademark language, my lords, is concerned with use in commerce. It is not a patent claim, or a trade secret, or a description of the abstract processes of something. This is for traders to look at and know, more or less, that there's a product there or a service there that they know and probably call by that name when they consult it.
Would a backup service fall within the telecommunications class?
I suppose it would be conceivable that one could apply for. There's complete freedom of action when you apply for a trademark. You could apply for babies' bottles in the telecommunications class. There's a few cases dotted in the reports about where the courts are struggling with this sort of thing. But actually, that doesn't seem completely unrealistic, because I suppose one would be focusing on the telecommunications aspect. So there could be perhaps some sort of service that is both communicating and backing up.
And it would also be a computer service for accessing. Would also fall within that class.
It could do if it were put in the communications class. There would be a slight conflict, because a backup is essentially a dumb. There's no message being communicated there from the machine to the other machine or disk or whatever, or cloud. There's no signal or human readable or understandable message. So we say it would look odd, but it might be able to be.
So it would look odd in telecommunications.
It would look odd in telecommunications. And it's no surprise that, of course, backup is not there. It's in class 42. Now, I'm going to be careful saying I rely on dissimilarity because it's in a different class. My learned friend points to section 60 of the Trademarks Act, but we say quite clearly that in this, that is the conventional class, in the same way that broadcasting is in class 38. And that would be where one would expect to find it. Now, telecommunications, I should just say, is a portmanteau word. First part, tele, second part, communications. And we say that second part is important. We've got the tele, but we don't have the communications. That's a big problem, we say, in relation to all of the terms that are relied upon in that class. Now, my lords, I wanted to take you to another topic briefly, which is the other goods and services that were advanced by my learned friends towards the end of the day yesterday. And you can find their schedule at the back of their appeal skeleton, which is the core bundle tab. Sorry. Oh, that's my paper's right.
Tab
Tab 4. I'll just use the one on my computer. Okay. That's the schedule of additional goods and services that are coming in now, combined with the original two, or the original one that the judge found at trial that actually was the only one for 2.5 years. And then we got the computer services coming in at the form of order hearing. And now we've got on appeal, we've got all of these as well. In fact, that's the short story of how these terms came to be alleged, because in the rarefied atmosphere of this court, my lords, you might be forgiven for thinking this was a case about the top 8 or even the top 2 or whatever they are. The fact is, email services was never actually even pleaded. In the particulars of claim, there were hundreds of terms expressly pleaded, and email services was not even amongst them. Of course, the marks were annexed to the particulars of claim. They contained thousands of terms. I'll show you those later. And the pleading said, we rely on the following, hundreds of terms, without prejudice to our reliance on the annexed terms. And that was the position until about 3 weeks before trial. So that was disclosure, evidence, everything in the case until that point. And out of all of that morass of language, they won on one term, effectively, after the CJ judgment. One term, email services, at the unpleaded term. And then the form of order hearing, they got another one in. Now, the email service, as I say, was against the migration, and the computer services were against the backup. And then we say, the extraordinary request in this appeal for this court to find, for the first time, infringement of the other goods and services. Those on which there was no finding below, where there was ample opportunity for my learned friends to ask the judge to reach a finding on that, or on those, just as they did that computer services one, the form of order hearing. Well, in fact, they didn't actually ask the skeleton, they asked on the day. So, but whatever it was, there was time between the period when he cut back the specification and for them to say to him, we want you to reach findings on these. And he didn't. They didn't ask. But they come here in fading light yesterday afternoon. Mr. Roberts put into bat, casually swatting at our USPTO application as evidence of similarity, or a stray paragraph of Mr. Schwartz's witness statement. We say that's not really appropriate. There has to be a first instance finding. But I want to make it clear that our basic position, my lords, is that notwithstanding all of that, we are prepared once again to take on the substance of this new case and meet it on the merits again. Because we say that in relation to these other goods and services, if they could come into the case, Sky's case on construction is hopeless again. If
when you say come, I'm not quite sure what you mean by come into the case.
Oh, my lord.
Until the judge cut down the specification,
yes,
you couldn't really
no.
Couldn't really argue for the detail of the findings you're asking them to make.
Right.
I think you accept they were pleaded. You say lots of other things were pleaded as well.
Yes.
And that they did focus in their pleading on particular ones, but they said without prejudice rely on everything.
Yes. But then what happened was before trial they pared it down to the top 8. Mm-hmm. And then those top 8, the schedule that's in their appeal skeleton, that was the paring down exercise in relation. Yeah. So we got paring down in relation to 5 of the 6 terms that we attacked. 5 out of 6 were held to be bad faith. But from that point, they were entitled to say to the judge, right, these infringe, as they're saying now. These additional ones, not just computer services, which they did in the form of order hearing or email service. Those other ones. The
And you say
computer
they
services.
didn't.
They didn't.
And where do we get that from?
Well, I'm sure my learned friends will happily concede that they didn't ask for a finding from the first instance judge.
I don't think they will.
Okay, all right. Well, if that, then no doubt they can cover that in reply.
What-
I don't. What
Where should they? What document should they have asked the judge for findings in? Where do we find that?
Right. So between the date of the third judgment, when he actually did the redrafting exercise, and the date judgment, which is the form of order hearing, there was how much time? Oh, thanks. Let me give you this. Okay. This is the dates. Right. Yes, the resumed hearing skeletons were, so that was on the the third judgment was the 29th of April 2020. Following that, Sky writes to the court confirming that they withdrew their infringement claim based on everything else that was outside the case. And then we've got the fourth judgment. The date of the fourth judgment was, because we got an order shortly after. So whatever period that was. And
2nd of July.
thank you, yes. So we had that period. Now I should say that in their skeleton argument for that fourth hearing, they didn't ask even for the computer services. That was something stated on their feet. And it was on a new basis, similarity, and against a new part of Skykick's.
Yeah, and where's the skeleton for the fourth hearing?
That will be found for you, my lord. I think the point is not actually impactful because I'm prepared to take it on the merits anyway. But we say
You've made a complaint that they raised this at the last minute. I'm not sure it's
my lord, it isn't even really that. The criticism is that it wasn't raised below,
Yeah,
and therefore they're asking you to be a first instance fact finder.
but you're not asking this court to say they can't raise it
No,
here. as
no,
a
no,
result of
no,
that.
I'm not,
So
I'm not.
can we forget about it?
My lord,
Just
you
thinking
can,
that
you can
someone
forget.
has to write a judgment.
You can forget about the procedural aspect of
Yes,
it.
all right.
What I would say is simply, because of the way that the point has been taken, you don't have the material, you don't have the argument, you don't have the submission, and you're not looking at a first instance decision and errors of approach.
No, I understand
So
that.
that's really the only significance of it. But my lord, notwithstanding all that, we say we're quite prepared to take it on the merits. And if I can just show you this schedule. Where is this schedule? Here it is. This, I hope, will be an aide-memoire of our submissions on this. And to some extent, I will have foreshadowed these. But again, they're really for your... And I don't say that these are at all exhaustive in their summary of our position on each of these services. But because of the way that they've come in, we thought it may be helpful for my lords to see.
I asked Mr. Roberts whether any of this made any difference.
Yes.
Does it make any difference?
Nope. Not in our view. No, not at all. These are just not identical or similar to what we do. And it's a short submission. It may be worth just looking at the... Apologise, my lord. So, if you take the schedule and you look at the sort of the landscape schedule and you look at that alongside this table, it will make more sense.
Is that the schedule to our skeleton?
Schedule to my learned friend skeleton, which is at core bundle 4, tab 4, and I'm looking at page 49. So we say, looking at the first view, which is the first two, they're computer software this time. 1, 2, and 3 are computer software classes, goods in class 9. And my learned friend submitted, oh, well, we do software, it's software as a service. But of course, saying something's software doesn't make it similar. That's not a material similarity. It's got, I mean, software is fundamentally functional, purposive. It does something. An app on my phone that I can play a video game on the tube coming into work is completely different from software that runs a air traffic control system, as Mr. Justice Laddie put it, by way of example. These are words that are used to define the mark on the register. They're consulted by the public and trade. If we look at the first one, computer software supplied as part of or in connection with any television, video recording or home entertainment apparatus or service. Well, they're just not. They're not that. So we can, I'm assuming that Sky, I know a friend didn't actually get into the detail of this, but I'm assuming that's not even relied on, but if it is, he'll no doubt explain. The second one might be said to be a bit closer. Computer software supplied as part of or in connection with any telecommunications apparatus or service. And my learned friend has helpfully pointed out that telecommunications includes email. The first point I'd make is it's difficult to see how that helps him if he's not getting anywhere on email services. But secondly, this is actually quite limited. The words as part of or in connection with, in my submission, mean supplied with. By the way, it's supplied as part of or in connection with. Means supplied with or for the purposes of. We say that indicates that the software is integral to that telecommunications service, to its function as a telecommunications service. Again, looking at the core of things and what they really are, the judge approached this on the basis that he was paring it down to reflect the bad faith of Sky. He was hardly going to draft something which, in this respect, could be interpreted as being something that we did. But we say that it's quite clear that this is just not talking about anything we do. Now, I said before that trademarks are not about abstract terms, technical processes, they're not patent claims. And it put me in mind also of a hearing, a judgment that I'll show you later, of Mr. Justice Floyd in the Galileo case, which involved travel reservation software, you may recall. And I, rather manfully, was arguing that because there was functionality to mapping and functionality of calendars as well on the travel reservation software, that my software was those things as well. I didn't meet with success in my Lord's judgment. And it put me in mind of the example that my Lord gave in his judgment, which is the average consumer doesn't see the sale of a car as the sale of climate control systems or computers or satellite navigation systems, although cars are often sold with that built-in functionality. You define products by what they are, and this is defined differently from service. And if you look at so that's the second one. The third one is electronic calendar software, application software for accessing audio-visual and audio-visual content via mobile phones or tablet computers, game software. I mean, those are just things we understand, things that are not the same or similar to. Now, when it says as part of or in connection with, it's always tempting to think of examples. I'd suggest that that's talking about something like router software. The software on your router is supplied as part of or in connection with telecommunications service. Or maybe your Sky set-top box, which receives broadcasts and allows you to select from the menu and so on. That's what that means. You have to read these words through the eyes of business people consumers, people in trade, not in some abstract process way. So that's the first two. We come to number 3, my lords, and that is, I think, relied upon. We say the first point to note about number 3 is computer software and telecoms. So you supply them together. Telecoms, and my learned friends have split out the next word, telecoms apparatus. Computer software and telecoms apparatus. That's what it is. Well, you can stop there. We don't provide apparatus. And nor do we provide anything to do with something that enables connection to databases of audio-visual media content, effectively. Let's call it media content. Audio-visual, and documents. Media content. We don't do that. We don't do those things. We don't do any kind of apparatus. We don't do any kind of connection, databases of those media. Coming to number 4, storage.
The audio-visual and/or audio-visual qualifies both content and documents, isn't it?
Yes, we say yes. I mean, it's a bit curious drafting because it's the judge's own drafting, I think I finally understood what it means, which is the audio-visual and/or audio-visual run together. So it's either audio, so radio, visual, non-audio visual, and then audio-visual. So you've got your 3 kinds of sort of media and documents. So it's for all of them.
Did the judge apply that construction when he came
He didn't construe it at all, my lord.
Did he apply that construction when he came to item 8?
I'm sorry, he did not. Yes, I anticipated that's what you asked me. No, he didn't. One of the criticisms we make is he didn't make any construction. He just said they're obviously highly similar, identical or highly similar. Mm-hmm. There was no grappling with the terms. And that's part of the obscurity of the reasoning. We say it's plainly wrong, but it is quite difficult to understand what the judge had on his mind. Clearly, he didn't think class number or the fact that telecommunications was relevant. He didn't mention that. But he didn't even do a sort of grammatical, ordinary language analysis.
And what is visual content? I mean, is
slides, I guess, or something like that.
Yeah.
Still pictures. You do your photos, your Apple photos or something.
What about an email? Is that visual content?
An email? No, I mean, I would say not. I mean, I think it's a bit like that strains the language a little bit. I mean, an email is a message fundamentally, not visual content. It may contain graphics. We say that looks. So I was about to come to number 4, which was redrafted. This was originally data storage, and the judge drafted it as storage of audio-visual and/or audio-visual content documents. So one is storage. Now, I'm not quite sure which of the 2 services of ours are said to infringe this. Probably both, indiscriminately. The whole lot, and Cloud Manager as well, probably. We say whatever the allegation is, it's unfounded, because backup, fundamental purposes, backup, migration, same, and the manager is the control system for the business. I'm not sure how significant that is in the case. But we say it's not about storage. You don't go to Skykick and say, I'm running out of space, I need some storage, and get Skykick service. It's just not consistent with the evidence in the case at all. It's only if you start to unpick particular processes within the Skykick portfolio, you might say, well, look, there's some transmission of data from one machine to another, and therefore that's communication. It does strain language, and it is artificial.
Can I just be clear? You're not suggesting there that audio-visual and/or audio-visual governs documents as well as content?
When my lord says governs, you have to provide them all. We do say that. Your service or your good has to be aimed at all of them, because there's an and, not an or.
So I understand.
Is that
the data storage means you have to provide storage of content and documents?
Of all the things afterwards, yes, yes.
But the documents themselves don't have to be audio, visual, and/or audio
No,
visual.
there would be, so the media, I suppose, are files, the media files, JPEGs or whatever, and then the documents are the docs or whatever, might be, yeah.
So if you merely provided storage of documents, that wouldn't be good enough.
It would not be covered by, they wouldn't be identical to that anyway. It wouldn't be identical.
So I thought you answered my question in relation to item 3,
Yes.
that the audio-visual did qualify the documents as well, but when we come to item 4, it doesn't.
I don't think there's a difference because I think this formula was adopted for all of the items. So it's...
If there's no difference, which is it?
It is what this service, to be identical to it, you'd have to do all of it. I'm not sure I understand the meaning that my lords are putting in terms of governance.
Do the documents have to be audio-visual and/or audio-visual?
No. No, they're
No
separate.
in relation to 3 and no in
No,
relation to 4?
documents are something different from the audio-visual content, yes. Sorry, I think I've finally understood it. It's my fault. I've completely...
That
Yes,
must
yes.
be right, mustn't it? Because
Yes.
you don't talk about audio,
Yes, yes, yes,
visual,
of
and
course.
or audio, visual documents.
I think I was at cross purposes.
Yeah.
Yes, exactly. So then we come to telecommunications services. And the short point there is, you'll see in the third judgment, that didn't go anywhere. That did not go anywhere because it fell into two categories, either email services, which didn't add anything. It's a double beat of infringement on the same thing. So it doesn't help my lords, my learned friends. And insofar as it was other non-email telecommunications services, it was said by the judge to be weaker. So how can it be in a closer relationship to our service? And as we say, that's fundamentally right. We're not a telecommunications service. It really doesn't matter which of them you think of. You can cast your eye down the alphabetical list of Class 38, or indeed, if you want a shortcut, just look at Sky's Class 38 trademarks. I think they've populated every single term listed there. I can't remember. We'll look at it in a moment. But none of them are similar to what we do. None of them are what we do. None of them are similar. So that's electronic mail services, telecommunications and electronic mail. Internet portal services, about that, I mean, my learned friend yesterday didn't really define what they were, beyond saying that portals were as trendy 10 years ago as SaaS is now. We heard no actual definition. I would suggest the average consumer thinks of that as the design of interactive websites containing information from various sources, clickable links and that sort of thing. It's a portal, it's not just a flat website containing content. Trying to avoid technical language, my lords, because this is basically something that people, an accountant might say, can you upload your this year's expenses documents to this portal? So that is what the people that design those portals are like website designers. That's not what we do. It's not similar to what we do. You don't come to Skykick and say, I need a portal so I can get customers of mine to upload their documents, or I can provide information on these forums or whatever. It's just not what we do. The final one is the computer services. I should just say, just going back to portals, the judge did reach a finding on that, because you can see it wasn't amended at trial. And he said, it is debatable whether it's similar.
Is that a finding?
Well, exactly. We say it's a finding that it's not. We say it's a finding that it's not, because he didn't find that it was similar. It's debatable. He who asserts must prove. This is confusion case. I'm facing an injunction here. He's got to, my learned friends have got to establish it. Now, moving along quickly through my roadmap, we say that is pretty much the position on infringement. I've got some other points that we make about more generally, which I'll come back to in relation to some of the authorities and so on, really for my Lord's notes. I'll have to look at the Altechnic case, the Pathway case. I'll try not to be too long, but I propose just to quickly go through my route map if I can. Bad faith. In the second bit of my... Sorry.
Have you dealt with section 10.3?
Yes, on 10.3 and on passing off. The passing off case was hopeless. I think my learned friend at trial dealt with it in less than 30 seconds on his feet. And then they criticised the judge for being terse in his judgment. It was belt and brace. It's difficult to see how that had any merit, given that there's been 9 years of side-by-side trade, so to speak, without an instance of confusion, and parties do completely different things. And it's well established in passing off that although there's no common field of activity requirement, there is the degree of proximity of fields of trade is relevant. Judge held no misrepresentation. On 10.3, what I'll call 10.3, but my Lords know I'm talking about dilution, unfair advantage. That was replete with problems, the entire case. First problem was my learned friends didn't have a reputation beyond the admitted, in the defence, reputation for the things that Sky is known for. Telephony, broadcasting, and broadband. Perhaps less so, I don't know. I've got Sky broadband, so maybe that's why. But they didn't have reputation for all these other nooks and crannies. So they didn't help them. If they couldn't establish the link, and the damage, or the harm, the dilution, whatever it was, on those core goods, they were never going to get anywhere. And that's basically what the judge did. I mean, he was generous to say that they had, that there would be dilution if there was confusion, because it didn't matter. They just didn't get off the ground on this. And when we got into dilution, I mean, the notion that somehow the word Sky is diluted when you've got thousands of users.
Well, can we have a look at what the judge did find?
Yes.
We've got into a bit of a muddle yesterday afternoon. It's paragraph 317, isn't it?
Yes. So, yes.
Reputation, as you say.
Reputation. So we accepted telephony
Admitted reputation.
and it's just, he said, Sky contend and I accept the reputation is not limited to domestic consumers but extends to business consumers. Sky also contend that their reputation extends to computer software, electronic mail, which he found infringement of, and advisory services. I don't consider the evidence establishes that they have a reputation for those goods. I think what's going on here is actually quite a subtle finding, because it's not that they haven't used to some extent for email. It's whether they have a separate reputation for those goods and services that isn't dominated by their reputation, which is household name reputation, and was admitted as such right from the outset. In relation to TV,
finds that there is a link.
there is a link, and he then goes on to consider the two forms of harm, or the two. There was no tarnishment allegation, despite my learned friend's discussion yesterday about what would happen on a damages inquiry about damage. There was no tarnishment allegation. There was only classic dilution and unfair advantage. Dilution, you've got to show an effect on the consumer behaviour. Very difficult to succeed on dilution. I don't think I'm aware of a single case in which someone has succeeded on dilution in the absence of having already succeeded on confusion. That is a new one in the real world. I mean, an infringement case. And that is hard. Unfair advantage is a little bit less difficult. But this isn't an unfair advantage case. This was never an unfair advantage case. The idea that Skykick adopted its mark to appropriate or free ride on the coattails of Sky is a risible one. It's a risible submission. It wasn't really advanced. There was some discussion of the manner in which Skykick had adopted its name. That went nowhere, and that was the end of it. The idea that there's something in these points, but my Lord, he's quite clear. The judge finds on the facts, Sky have not established any case of unfair advantage. It's not suggested that Skykick intend to take advantage of the reputation, and there's no basis for believing there's any likely to be any transfer of image. And so really, it wasn't surprising to us that my learned friends seemed to be almost at odds with each other as to the degree of significance they were prepared to attribute this part of the case.
So, judge is approaching all this on the basis of an assumption contrary to his findings that there is no likelihood of
Yes.
confusion.
Yes.
And where the case appears to fail is in 319, because on that assumption there's no real risk of any detriment to the
Yes.
distinctive character of the marks.
Yes. I think
If there is confusion,
Yeah.
on the other hand, on the alternate assumption, if there's confusion, where does the paragraph C case fall down?
Nowhere, because none of the things in which it had a reputation for were relied upon as the top 8. That's the short answer. Well, what was going on here?
When you say no, it falls down.
Falls down.
Because the reputation is not the right sort of
Yeah.
reputation.
Because the degree of proximity is a bit like passing off. The degree of proximity between the goods in which you have services in which you have a reputation and the dissimilar but still linking goods and services is relevant to whether there's harm. That the Court of Justice said that, I think, in the very first of these cases.
But the judge hasn't made any findings about that.
No, not at all.
And one of the points in the appeal is whether he was right
Yeah.
not to make any findings about that, because Mr. Hobbs says, when it comes to the inquiry, I want to be complaining about the damage caused to the distinctive character of my trademark.
Which trademarks and for which goods and services, I would ask him to cover in his reply, because the issue is this is one of the sleight of hands in terms of the bad faith registration. My learned friend defends it on the basis, we're entitled, we're a big mark, we're really well known. We really do need to protect all these exotic functions. When you protect that by your core reputational goods and services, you don't protect it by adding additional protection and registering, populating the register in every nook and cranny. That's the point. And this is what the judge was finding here. As we read this decision, my lord, and this may be of assistance, this is no more than a procedurally economic way of dealing with 10.3. So to the extent it was the same as confusion, so I'm going to assume that confusion causes dilution and detriment and unfair advantage, just for argument's sake. I'm going to assume that. I'm only looking to see whether there's any separate sphere of application. Does it add anything to Sky's case?
But what goes down the sink if you do that is a finding that there is 9.2c infringement, which may carry with it a wider scope of relief.
Yes, I think the reason for that is because this was made before the ECJ had pronounced on the various issues. So the only one of the things in the top 8 that he found confusion on, not even confusion because it was identical, it was email services. And he expressly says, I don't find a reputation for those. So there's a basis right there for saying, forget email services. The only question might be whether my learned friend can establish some reputation for these carved out services. The problem for that is his problem, it's not mine, is that the judge carved them out after the evidence and after the trial. So there is it simply was not a consideration of whether he had a reputation for access and retrieval computer services. But for what it's worth, we very much doubt that he did, that they would be ever able to, because these were not the core.
Is that how 9.2c works? I thought 9.2c was all about extended protection.
Yes.
You've got a reputation, you're a very well-known mark, which Sky presumably accepted. It is a well-known mark in some spheres. And then you ask the question, not is there going to be confusion, but is a link created? And the judge said, yes, there's a link. It's going to be perceived as a sub-brand or whatever he says in 318. So is your answer really a good answer? That you haven't got a reputation for email services? And the whole point is you don't
Yes,
need
I mean,
one.
you need link, of course, but that's just the starting point. Then you've got to show unfair advantage,
Yeah.
harm, and so on, dilution.
If you're using a well-known mark
Yeah,
and creating a link in the minds of
yeah. That's not enough on
purchasers,
its own. That's very well established by the Intel case. Maybe I can come back to that. I wasn't anticipating there to be a great deal of interest, frankly, from the court on this point, simply because my learned friends were basically saying, look at our skeleton, and I was going to say, look at mine. But I'm happy to go into these points with my lord.
Yeah,
So,
that's what I'm trying to do.
yes,
Mr.
well,
Hobbs
I don't
has
know
a-
if...
Mr. Hobbs has an alternative suggestion,
Yeah,
which the court might consider, which is that to the extent that any of these additional findings, both on straightforward infringement and paragraph C infringement, to the extent that Sky can establish they matter to the relief which they're claiming in the inquiry,
yeah.
that they should be free to raise those on the inquiry. But there'd have to be a sort of hurdle that you get over first, that it's actually going to make a difference to the relief.
Well, I'm not sure. Can't see how they do, because some of the functions he was talking about also apply to double identity cases. So you don't get more money for damaging the essential function versus the advertising function or whatever. And in any event, those functions are protected under double identity cases. So I'm not quite sure how they are led to, that he can amortize those, monetize, I think is probably the better word, of those particular functions. But, my lord, the case on 10.3 was, we say, even weaker, because I mean, all the things I've been talking about on construction are obviously our fortune.
Well, I know you say that, but what do you say about the procedural suggestion?
Well, can I take instructions on that over lunch? Yeah.
Thank you.
The bad faith appeal. So in the second half of my submissions, I'll focus on that, just in terms of giving you some references. We make a number of broad points that about Sky's approach to the legal analysis. We say this whole dishonesty test, Sky are essentially battling an imaginary foe, a general test of dishonesty, fraudulence, fraudulento, I think they called it, which they invoke and then duly defeat, arguing that their behaviour did not satisfy that standard, that they were in effect not dishonest enough. That's the submission. I will say that Sky's chimera test of dishonesty just does not approximate to the CJEU test in this case, which I'll show you, a test which itself confirmed a previous ECJ test in Cotton, and which has since been confirmed in terms by the General Court in the Monopoly case, the Evergreening case, that's caused quite a lot of attention and potentially panic in the EU. Our case is not an outlier. Our case was a paradigm case of bad faith. Now, being an ECJ test, this test is not succinctly expressed, and it doesn't trip off the tongue, at least in English. But I will suggest, my lords, that it is tolerably clear, and it was that test which the judge applied in this case, and that test was adopted with full knowledge of the full sweep of facts. They were sent the judgment, essentially, within the order of reference. It wasn't summarised very much. Essentially, the infringement material was lifted out and other issues, but all of the detail on bad faith was there. Now, it was interesting listening to Mr. Hobbs characterise the evidence of Mr. Tansey. He wasn't there at the trial. He came in on appeal, Mr. Hobbs. So he wasn't party to the rather excruciating episode of hearing what Mr. Tansey had to say. He was cross-examined by me and the judge in almost equal measure, and it didn't go well for him. Now, what do I mean by that? I don't mean that he was disbelieved. On the contrary, he was very much believed. And we can see the results of his words in black and white in the key parts of his evidence relied upon by the judge. Yes, he was an honest witness, but he thoroughly gave the game away as far as Sky was concerned. I'll show you Tansey's evidence a bit later on. I mean, it's in the judgment. I'm not going to be going through the transcripts or anything. The fact is that Mr. Tansey admitted, indeed submitted, that Sky had not done anything wrong by applying indiscriminately, by applying without reference to its business needs now or ever, and in marks comprising thousands of words, each containing general category or class terms as well as more specific ones. It was just not part of the thinking to ally that in any way with Sky's use. There was a separate approach, which was applying for the marks because you could and for their own sake. Now, he justified the application strategy in the passage that I'll show you on the basis that it contravened no known law or rule or practice, and because previous applications by Sky hadn't troubled trademark registries across Europe. He said that having broad protection coupled with long lists in lengthy marks provided what he called clarity for third parties. Clarity has a particular meaning in that context. Now, I'll show you precisely the passages of those, but it comes down to this. There were three ways. I learned a friend yesterday who was talking about computer software and everybody does it and there's nothing wrong with broad terms and a lot of terms are broad. That's not the accusation here. You can apply perfectly innocently for a broad term. You can apply for telecommunications and be completely innocent in the way that you do so. And you can apply for a narrow term in bad faith. That is not the issue. You can take from an approved pick list, bad faith or good faith. But what Sky did is they had a strategy of not caring about whether it was linked to the business. Their policy was to apply, as the judge put it, deliberately broadly, and they did so in three ways. One, specific terms they knew they would never use. Tuxedos, bleaching preparations. The marks are full of those sorts of terms. Gladstone bags. So that was the first type, the specific terms they would never use. Two, masking terms. Terms that conceal hidden words. Now that was the point I think that my Lord Justice Floyd was putting a moment ago. Some of these classes, if you apply for the class heading, and if the rule of interpretation is you get everything, then a savvy attorney knows that you'll get quite different things than are actually contained in the words of the text. Some examples are, if you applied for building services, you implicitly got pest extermination. So you sort of keep it as a trap. If you applied for surgical and medical apparatus, you got condoms. This practice was pretty outrageous. And my learned friend is right that the office had encouraged it to some extent. But listening to him, he almost suggested that it was compulsory to do it. It wasn't compulsory, and it wasn't the practice in this country where Sky are based. It was optional, and it all came about because the EUIPO wanted to save money. They didn't want to have to spend money translating people's long goods and services. Much easier to just translate the words of the class heading. So that was the practice. And it was encouraged, but it was not compulsory. That was type 2, these masking terms. Type 3 was the broad terms, the umbrella terms. These were not masking, but they were, I won't say absurdly broad, they were extremely broad. And the best example of this is computer software. Because when someone applies for computer software, you can say what you like about it, and we'll look at Chair Entertainment, which my learned friend places such heavy reliance on, which says essentially nothing. The fact is, as many judges in this jurisdiction have indicated, there is a problem when someone covers computer software. It's a bit like having a registration for machines. It means nothing. It's astonishingly broad. I also want to clarify terminology here. We don't suggest it's unclear. It is quite clear what computer software is and what it's not. It's imprecise in the sense of not defining what the computer software does, which is the fundamental characteristic of computer software. And that's why in the US, the approach is you can't apply for it. You've got to designate what kind of software it does and what it does and what field. That might be going too far. I don't know. This debate will be had at some point and will be grasped at some point because you can't have people applying for essentially machines, or because effectively that can be, anything can be said to be similar. So that is their third strategy. They did all three of those particular kinds of strategies, and these were acknowledged in the judgment. In paragraph 4, the judge talked about the length of the marks and the strategy of using general terms followed by specific. Mr. Tansey was asked about this, his evidence deals with it, and there was 3 types of stratagems, but one policy. One policy to take marks for things without reference to Sky's business. The fact that they saw nothing wrong with their behaviour, that Mr. Tansey candidly says, if I thought there was anything wrong, I would have changed my behaviour, is not determinative. What matters is whether that is bad faith within the test laid down by the ECJ. And we say, not only do they apply for these 3 terms, there was a number of other background facts. We have incredibly long marks. We have the repetitious nature of the language used. Things are separated out. I'll show you later, but you'll see software here, and then it'll get into different kinds of hardware, and then it will be back on software, and then it'll be software defined 5 different ways, and then telecommunications will be done in the same way. It'll be communications, telecommunications, broadcasting telecommunications, telecommunications by wire, telecommunications by satellite, telecommunications by this. And we have 8,000 words in a single mark. Now, I don't know if my learned friend, with his long experience in this branch of the law, has ever seen marks of this length, because I certainly have not. Mr. Justice Burse, as he then was, commented in the one hearing he did on this, that these were of extraordinary width. I put it at least that high. So you had these things, these particular approaches being adopted in marks of that length. Now, we say there was one policy for all of this, and it was not linked to the commercial rationale of Sky. You would have thought that after the ECJ judgment, after Monopoly has now confirmed that, it itself confirmed the Cosson case, my learned friend would be here before this court saying, we got it wrong. We apologise. We now know that's not the law. We've stopped. But he doesn't, and they haven't stopped.
Well, would it extirpate the previous wrongdoing if they had stopped?
Really, I make the different point, which is this is why my learned friend still argues that what they did was not bad faith. He talks about a blind spot in the law, a blind spot that you get trademarks by registration. It's not a registration of title. The mere act of saying what you want gives you rights. You design your own right, you draft your own right, and that is said to be a justification for applying in this way. My lord, the opposite is the case. This subverts the entire policy of the Trademarks Register. This makes the bad faith doctrine more required. It's the only way that you can put a brake on this sort of behaviour. It's the only way that you can have the register meet the objectives that it was designed for. It's supposed to be
from revocation for non-use.
My lord, yes, but that was an issue that was featured quite large before the ECJ. After 5 years, but for 5 years, you have untrammelled rights to level those marks, both in infringement actions and oppositions and so on, against all comers. You register for fireplaces and off you go. You sue anyone you want, and you wrote that mark. It's not like a patent where there's some connection to the real world and some invention, or let's say a design which is a lady's dress which is beautifully done, or something somehow new, or even really any trade secret. Most IP rights have some connection to the real world. They're not simply a self-registration DIY, draft your own right, which is what my learned friend is essentially saying they should be. And what is the purpose of the register? It's supposed to be a register of trademarks used in trade. It's not a register of reserved monopolies or reserved signs having no worth except to the purposes of bringing actions. And that's what the ECJ test is. It's about the trademarks having a connection to the real world. And they've been quite liberal, actually. Having a long mark is not a problem. Having a settled intention to use is not necessarily a problem. Not even knowing what you're going to use is not a problem. But actually setting out to apply for a mark for its own sake without regard to use, that is a problem. Now, two other facts we think my learned friend ought to have perhaps covered, and he maybe will cover in reply, on bad faith. Section 32.3 and the lie told to the UK IPO. This was essentially ignored in his submissions. And the CJEU was asked if our provision, Section 32.3, was compatible with EU law. They said yes, and it could be evidence of bad faith. I mean, that's pretty clear. The judge was accused of a lot of things by my learned friend, but he was generous, we say, in describing that statement to the UK IPO as partly false. It was either false or true. It was false. One can say that the consequences may impact on certain goods and others. That's
Well, take the example of, sorry to interrupt,
Sorry, yes.
computer software.
Yes.
Suppose you are a computer software company, you've sold one particular type of computer software. You register your mark for computer software and you declare to the UK IPO that you've used the mark for computer software. Is that untrue?
Lord, that is not bad faith. As I said,
No, I asked you
yeah.
whether it's untrue.
It's not untrue.
No.
The reason for that is because you have thought, I use computer software, this captures what I do, therefore there is a bona fide intention to use. If, on the other hand, you put in the same mark by a different applicant, who, let's say, he used to work for Apple, and he puts in the mark for computer software basically to steal a march on Apple and to be annoying, that'd be in bad faith, right? So it depends on why you apply for that. Sky's reason was, we don't care what we're going to use it for. It doesn't matter. We're allowed to do this, and that's different. So that's very different from a party that the fact that they can argue that they've got use within some of these millions of terms is actually neither here nor there. They were not applied for on that basis, so it doesn't matter. My Lord, or Justice Newey asked my learned friend yesterday why he was so concerned about the words purely as a legal weapon when effectively all trademark rights are essentially negative or exclusionary rights. And the reason I think my learned friend is sensitive about that is because the evidence that was called at trial, the evidence of Sky's witness, Ms. Campbell, was that they had prosecuted hundreds of actions against parties based on these and similar marks across Europe. Many were trading in distant fields. Some of them are touched on in the judgment. And this evidence, these 800 and counting proceedings across the world, I think there was 350 in Europe in the first witness statement, probably 20 or 30% more. There seemed to have been a spike around the sort of 2016, 2017 period, roughly when we were hit with our first cease and desist. These marks were not used defensively. Sky continued to launch proceedings today based on these and similar marks, always within the 5-year grace period, because you don't have to show use. It's just easier that way. These marks, during the whole course of the trial, were always one of them was in the grace period. And because they're all essentially the same, there was, in effect, no point in trying to revoke the 4 that had entered the grace period. The judge didn't agree with us on that. We've never quite understood why, because it seemed to us to be perfectly proportionate.
Miss Worthington, Queen's Counsel, excluded all the evidence about that as well.
Well, we didn't get to run that point, even though that is probably one of the most important points in this area of the law. So, anyway, those facts, my lords, were damning, and they were set out in the judge's judgment, sent to the CJEU. They had the judgment your lordships have. They were given the full sweep of the findings, the 3 ways, the verbose thickets of words, the length of the marks, the strategies, and the prosecution the deploying of these marks against many, many other traders, they didn't base their judgment on simply whether the Sky had applied broad, which was the way that it was presented. That was, they very clearly kept in their mind there was a separate question on whether broad or unclear was invalid under the IP translated basis. That was our big point. We wanted to win on that as well. We didn't. Fine. Actually, all the countries, all the member states were against us on that. I don't think anyone supported us, which is very unfair. But we did win on bad faith. Did win. And we won on this section 32.3 point. And it was quite clear that we did, because the judge looked at the facts that he had found and
You
said...
didn't win, sorry to interrupt again, you didn't win on the proposition that simply not having an intention to use is bad faith.
Right, I need to correct that, because it was not our case that simply having an intention to use was enough. My lord, this is another straw man my learned friend keeps erecting. It's not. There's no requirement of intention to use. There's no requirement to use narrow terms. There's no requirement to know what you're going to do. All of these things are relevant in the right case, but they're not determinative on their own. And I think I'm just going to read.
I understand it's not your case.
It wasn't before the ECJ. One of the questions was, question 3, I think, was, is it intention to use bad faith? And we said no. We said we answer that question in the negative. It may be relevant, but you can also have a lack of an intention to use without bad faith. So that was our basic position. I don't think I need to turn it up. That's not our case before the ECJ. And we say that the Advocate General, who my other friends touched upon yesterday, said of Sky, so you know the ECJ judgments tend to be a little neutral, not too fact specific, but the Advocate General said, in my view, where the applicant as Sky here was found by the referring court to have had a deliberate intention to acquire rights it had no intention to use, potentially inter alia to prevent third parties from using the mark for the sale of those goods and services, then there is bad faith. That is because the deliberate seeking of registration in respect of goods and services for which there is no intention to use to trade reflects an intention to abuse the trademark system. Now, he used quite strong language in that opinion. I think there's, he refers to abuse of the trademark system a number of times. And it's also interesting that the Monopoly case talks about abuse of rights, abus de droit. This is how it is seen in the ECJ. It's not about dishonesty. It's about taking advantage of the strict letter of the law to subvert that law for a purpose for which it was not intended. And that is the essence of the bad faith test as well. My learned friend as well, just as an aside, suggested that Evgeny Tenchev, the Advocate General, was the only person who cared about this laddie judgment about Mercury Interactive, and I couldn't help but notice that in the Galileo case, you yourself also mentioned that as being quite an important principle. That has been mentioned many times in the UK IPO. I don't know if I've checked, but I wouldn't be surprised if it's been mentioned by appointed persons as well. It's quite an important principle to understand that computer software is broad, and it really, you've got to find out what it's talking about by way of what it says it can do. Extent of validity, that'll be the last topic of summary. And I will say, before I get into the sort of references and a bit of paperwork, I will say that the schedule I took you to earlier shows, so that the schedule attached to my learned friend's appeal scout, this one. If you look at the fact that he has, that the judge has amended 1, 2, 3, 4, 5, yes, 5 of the services of the 6 that we attacked, the implication is there's bad faith. That's why they were amended. That was the consequence. But funnily enough, this is a situation where neither side is that happy with what he's done. We'll live with it if we have to, because we say we escape it. But the proportionate consequence, but Sky want to get rid of this. They say, no, even if they win bad faith, even if they win bad faith, I think this is the case. I don't know if I might be able to correct me. Even if they win bad faith, these should not be touched. There should be no amendment. even though they've obviously withdrawn all their other terms, the bleaching preparations have all gone to fight another day, and even the ones here that the judge has obviously seen fit to amend, because otherwise seen fit to amend because of bad faith, the learned friends say no, leave it alone. We say that's astonishing. They should, if anything, lose these terms. If you think about what the vice is here, the vice is not, you didn't use this, but you did use that. The vice was, you used language to abuse the system. It was the very drafting exercise that was the problem. And these were widely drafted terms that the judge had identified as being part of the policy, and they should have gone. Now,
So just to follow up on the example that I gave of a computer software company that applies for computer software and only has one program, you answered that
that would be could be in good faith, I think.
that could be in good faith. But you say when Sky did it, it's bad faith.
Yes.
Now what?
Well,
What
because
precisely are the facts that you rely on to say to maintain that differential?
if you, if I can ask my lord just to take the judgment. So they obviously had plans and did sell some software. I mean, they did supply software. You've got Sky app on your phone or whatever. So we can't deny that. But that wasn't the approach for these marks. They had many other marks. And in this mark, they had many other terms that weren't in play. All the judge was doing was saying, look, these terms are applied for inordinately widely, and I'm going to knock them back. And we say that was a bit odd because the degree of cutting back was not sufficient, first point. But actually the better thing to do, the better and most proportionate punishment in these circumstances is to delete it. If you take your innocent applier, they won't have been held to be in bad faith. But let's say, for example, they've applied for fruit and computer software because they want to steal a march on a competitor for something. And that is just bad faith, the fruit aspect. You wouldn't suggest that there would be some kind of fruit that it would be possible that they would sell. The punishment that fits that crime is deletion of fruit. But that's because they had no intention to use. In a case like this, the vice is the actual design of the language, the choice of those words, as opposed to set-top box software, router software, which is what they do, or plan to do, or may well do in the future, of various kinds.
But the innocent applicant can get computer software.
The innocent
Sky can't because what?
Sky can't because they applied for that without reference to their own use of computer software.
So they didn't go through the thought process.
They didn't go through the thought process. There was no sort of thinking. And that's important because had they done so, they might have thought, actually, why don't we say application software for streaming of live broadcasts? Why don't we say set-top box software? Why don't we actually do our job, think about what we want as a monopoly, and draft it accordingly?
But the innocent applicant probably didn't go through that thought process.
He might not know, and that's innocent. And we said that to the ECJ. There may be a lack of intention to use, but if that is done innocently, then that's not bad faith. I mean, it's just one of the things in the mix. There is no two cases of bad faith that are alike, my lord. I mean, they're all different from each other. And it may be that this one would not be repeated, at least to this degree. Again, I'm just asked to just check something, my lord. I'm just going to... Yes. I mean, it's the final sentence of paragraph 250 of the judgment that is the sweep-up paragraph when the judge has considered the three ways that I was discussing earlier, the specific terms not used, the masking, class headings, and the umbrella terms. He says, I'm forced to conclude that the reason for including such goods and services was that Sky had a strategy of seeking very broad protection, regardless of whether it was commercially justified. So when you put an application in for computer software in those circumstances, that's different from the accountancy software manufacturer startup who's come up with a whizzy piece of software and chances his arm with a bit of a broad specification. That is not bad faith necessarily, although I don't want to prejudge any case in this field. So, my Lord, we say deleting was the punishment that fit the crime. And in fact, my learned friends have a submission in answer to that. Right throughout their skeleton and on his feet, they say, look at the light drafting that the judge did. How can we have acted in bad faith? That's the submission. As if the light punishment that they received somehow reflects on the lack of seriousness of the behaviour. Well, we put it a different way. We say the punishment was too light. It didn't suit the crime.
And both sides.
Apologise by using that
Both
sort of language,
sides.
but you know what I mean.
Both sides criticise the exercise.
Yes.
Excuse me, the judge indulged in with coming up with what he regarded as a fair specification. I mean, is your position that that was wrong in principle of him to do that?
Yes.
So that your case, the case is really quite polarised then. Yeah. Mr. Hobbs saying you shouldn't have got involved in this and left it alone,
yeah.
And you're saying you shouldn't have got involved in this and should be struck out.
Exactly, my Lord. This is why I wanted to summarise my position. I know this might seem like a long summary, but
it doesn't mean to say that this court couldn't say that the judge was
correct,
actually justified.
Yeah, absolutely. And that's why I wanted to deal with instruction and show you how these points interrelate. I say I win if it stays, or it should be deleted, and obviously I win.
Yeah.
What shouldn't happen is that it should go back to how it was. That should not happen in the light of the bad faith. So we say that the judge's basic approach there was wrong, because what he did is he approached it as if it were a revocation case. That's the principal thing. He didn't actually characterise our submission correctly. It doesn't matter. He went wrong on this. He approached it on the basis, in a revocation case, for the benefit of my Lords, I know that my Lords have also done cases in this area, but revocation is about after 5 years registration, you get your mark pared down to the use that you've actually made. You can't keep use that you intend to make. It's got to be the use that you actually made, the category of use. So you might have computer software. You'd never keep that after 5 years. It would be travel reservation software was actually the case that I had before my Lord. You would get that. Now, but you can't say, oh, well, I'm planning to launch it to another area. But you've acted in good faith in a revocation case. You've just been, after 5 years, trimmed down. The judge actually gave Sky more than a good faith use applicant would get a revocation. Why do I say that? First of all, the judge gave Sky use that they could reasonably make in the future, which you'd never get. The judge put the burden on us, not on Sky. In a revocation case, under Section 100, the burden's on the proprietor. So it's the proprietor has to come forward and say, this is what I've done, and the tribunal or the court says, right, that's travel reservation software. That's what you're getting, no more. Sky never even said what they did. They didn't tender a fallback specification. We were the ones that did that, and we're criticised for it. The proprietor of the monopoly benefits from the amendments that were made and didn't even ask the judge to make them. And we say that gave the judge, leaving aside procedural issues, that gave the judge no material to work on. We said, well, just at the very top, you should just give them what they showed at trial, nothing more, because you cannot assume they have. Just treat it, if you're going to treat it like a non-use case, that's it. But he didn't. He gave them what he called a penumbra, extra use. That was manifestly unfair. And we say, for the reasons I can show you in the ECJ judgment, the approach was for bad faith, was that if you haven't, or any ground of validity, says the statute, affects those goods and services only. So the question that was before the ECJ was, what are those goods and services? Those, which we said, the whole mark, we said it's the application. They said, no, it's those goods and services. The ECJ answered it on the basis it's the goods and services specified, the registered goods and services. That's important for this reason, because the words that are actually in the mark contain, obviously, a hidden, because they're umbrella terms, number of things. But they're not actually registered. They're not specified. And I'll show you the test in a moment, which shows that the ECJ was on our side on this. The ECJ was saying, they've applied for all these bad things. Those are bad faith. Delete. Those should be invalidated. And it's a bit of a jury point, my lord. But when I show you the marks, they lose nothing. They have extraordinary long marks. They've got all of these same terms kept in different ways in their mark. There's no downside to them. It's just they don't want their marks touched in the light of this established bad faith. Whereas we care because it matters to us as we're facing an injunction on this. I mean, this is not really a case that should have been decided this way. The only learning on this is the Advocate General's opinion, Cockott, in the Cotton case. And she knew that the Skykick case was coming. And she commented about this issue, about what happens if there's bad faith, what gets deleted. And she says, effectively says, I don't want to tread on anyone's toes. But the fact is that if you just delete the things that they didn't intend to use and allow them to keep the things they did intend to use, then you're giving them no more than that to which they'd been entitled in the first place. So you incentivise bad faith, because every single applicant says, all right, well, I'll just put in everything. And if I'm ever discovered, and the burden's on them anyway, if I'm ever discovered, I'll just get what happened, what I could have applied for. That can't be right. The Advocate General's opinion is absolutely compelling, we say, on this point. The Advocate General Cockott was quoted by Tenshev, and Tenshev was followed in 109 of the judgment. There is a thread here, and we say it's quite clear that in a case such as this, that different cases may involve different considerations. A lot of cases, the applicant will just lose the whole mark. Cotton was a case like that because he'd effectively pinched, I think, his distributor. He was the distributor, ex-distributor, and had pinched his agent's mark, the principal's mark. I think that was the basic fact. In those circumstances, the pinching cases, yes, of course, you lose everything. But in a case like this, where you're abusing the register, you've got to be quite careful that the punishment or the response is proportionate to that and reflects that. And we say that wasn't done by the judge. Well, Lord, that is the summary, I'm afraid, for an hour and a half. I will actually probably be quicker than, because I'm just going to give you references on various things and pull out some of the authorities. So if I just go back to infringement for a moment. I wanted to show you the pleadings. If you've got the core bundle there at the back, you will see at paragraph, tab 19. This is the point I was making earlier about the way that the case has been levelled against us. The page 359, we have the marks listed, and there were 5 of them. And the first one that was listed was the EU mark ending in 352, and that used class headings at a time when Sky believed applied for that mark on the basis that it was covered all of the goods in those classes, and likewise for the one at B. So those deceptively short marks are traps. Then we come to C, which is a longer mark, a considerably longer mark, pages of terms there. And I'm just going to focus on class 9. And these are just the ones that are extracted from the mark. So if you look on page 361, computer software to enable data, searching data, encoded programs for computers and data processing, apparatus for decoding encoded signals, computer hardware apparatus, computer programs, again, just for good measure, computer software in the middle, again, just for good measure, computer software to enable connection to databases and the internet. I think that's one of the ones that my learned friends have still rely on. computer software supplied from the internet. This is the level of generality. And that is, if you look at C, in particular, for, but without limitation to. That's the way it was pleaded. Then we get to class 38. I'm not going to just read it all out, but you can see there what that's all about. Transmission and communication of text, messages, sound, pictures, provision of wireless application protocol services. It's all about the signal and the way that you get the communications across. Then you've got professional consultancy and information. What's notable is that you don't see email services there. And you don't see it in the class 38 one for the next mark either. That was the one term they succeeded on, following the CJ judgment up to the form of order hearing. But you get a flavour here, albeit an incomplete one, for the way the case is put. Now, we early on asked them to, we can't proceed like this, but what are we supposed to do? What are we fighting against here? All of the goods and services and all of these classes. Can you define or narrow your case? And perhaps we weren't as firm as we could be, but we were facing Sky, and we basically asked a Part 18 very early on, which was ignored. It was said to us that that can all wait for disclosure and witness statements, which didn't seem to be right, but whatever. But then even after that, it didn't change. And it didn't change until we served a second one in November 2017, a few weeks before trial, when we finally got, I think we wanted them to say their best 3, and they gave us 9, which I think has become 8 because of a certain tautology or whatever. I think that's right. Never quite remember if it's 8 or 9. But so we say that that was what we were dealing with, and I just wanted to show you the trademarks. And my lord will recall there was a spat about the bundles.
Simon, could you take them
sure.
to what you just said behind
sure.
tab 24?
Yeah. Do you want to take it in reply? So,
All right then.
so if you take the Skykick unagreed bundle, I have yours.
Presumably.
This one has the marks in it, I think. It's behind tab 8 of Skykick 1. And my lords will recall this was, there was a reluctance by Sky to show the marks to the court. They've never particularly liked showing these marks to any court. And they are, my one. Yeah, thanks. And they are quite telling. So I just wanted to pick it up from the back because I think the longest one is 8,200 words. That's the last one. And that was the youngest one, I think. So therefore the one that was in full effect. And if you pick it up from page 133, so you can see the full specification. Now, I would just note in passing that this contains 8,200 terms. One can spend quite a lot of time just discussing email services or computer services or whatever. Someone is supposed to be looking at this, maybe getting advice as to whether they infringe. And of course, that's the intention. These vast lists of terms, far from providing clarity, as Mr. Tansey put it, provide total obscurity and deterrence. The Class 38 one is on 133. You see it starts from telecommunication services, mobile and fixed telecommunication services, communication services, satellite, cellular and radio communication services, broadcasting, transmission and communication services. I mean, this is the sort of thing we had. Can I think of another way of putting these words with the word and, or, flipping them in order, maybe doing a subcategory, Then if you look a bit further down, let's say about 2/3 of the way down, we start to come into the message sending services within Class 38. Transmission of text, messages, sound, pictures, telecommunication or communication and or broadcast of audio-visual content, communication of information, data by radio, telecommunications and satellite. I mean, if you've got telecommunications, what's wrong with that? The communications apparatus, in the case of breakdown, computer-aided transmission of messages and images, and so on. And we don't see anything about email there. We go down further, about halfway down the page.
Which page are you on now?
Sorry, 134 now. Yep. You get to rental and leasing of communications apparatus. Electronic mail services. There it is in flashing lights.
Sorry, I've lost you.
It's very difficult to find.
Not that easy.
I'm not a bit surprised. It's 134
Yep.
of the document behind tab 8. About halfway down, sort of just over halfway down, you hit the words
I
rental
see,
and
yes,
leasing.
the electronic message.
There it is. And then it's got, just in case you were in doubt, telecommunications services relating to the internet right after it. Just in case you were thinking that we're getting a bit too specific. I mean, this is astonishing drafting. And it was self-evidently taking advantage of the system. The judge was aware of it. Mr. Justice Burse was aware of it. Once the AG was aware of it, the ECJ was aware of it. There is no doubt about it. Then I just want to show you where computer services comes. If you look at page 136.
At the moment, following the complaint about the drafting.
Lord,
I mean, what it seems to me to be doing is sort of filling in the interstices as fully as they possibly can.
yes, covering off every single way that these things can be expressed. There's no order to things, particularly. Things aren't really grouped in any kind of way that would make it accessible. I'm not saying there's a duty to do so, but it is. I know a friend said there's case law that says the mere length of a trademark is not a ground of bad faith. We agree. We agree. But when you look at this rather stress tests that proposition, because they didn't have this mark in front of them when they made that submission. This is an extraordinarily long thicket of terms. It's very difficult to know what they mean. They're expressed at a level of abstraction in some respects and then specificity. And by the way, the judge did not reach a finding on the mere length of the terms. I mean, but it's just the context from which these terms are plucked that I submit is important. And was the real world position of my client? My client was West Coast.
Well, your client didn't even do a search for trademarks.
Yes.
I don't know.
And if
I
it
don't
had
see
found...
how they come into the picture.
Yes, and if it had found the mark, what would have happened was if it had finally found the term email services, I'm not sure why it would have thought that email services would have been the one to worry about. Because actually there's nothing in class 42 that does what we do. There's no migration or data, backup, not. And so if it had actually found email services and then said, oh, we better keep away, they would have rewarded the bully's behaviour. That's exactly the position. So we say, for a very long time, we didn't know what goods and services they were relying on. They eventually did. And we say that the case, as it has emerged and now morphed again on appeal, is a fluctuating and unfair one. We also say that the judge didn't have the material because the laws may know that when it comes to a likelihood of confusion, unlike identity, you've got to show when you're trying to show similarity of goods or services, you've got to normally address what are called the canon factors, at least in name, and establish that the trade channels are the same, the users are the same, the purpose or whatever. These factors are variable, they're not exhaustive. But I thought I'd just show you canon, which you will find in the first of the authorities' manuals. This is probably one of the most cited cases in European trademarks law. It was the second or third big one after Sabel and Lloyd, and it's constantly cited for its authority. I say that because my learned friend I heard yesterday tried to rely on a general court judgment that he said goes against it in some way. To the extent that they did, they were wrong. And to the extent that they confirmed what Cannon said, then they say no more than what Cannon said. But I wanted to show you paragraphs 22 and 23 to start with.
Which tab is it?
Sorry, tab 3.
Good.
This was a case where I think the Canon camera company was objecting to video cassettes, CANNON, I seem to recall. That doesn't matter. 22, it's important to stress that for the purposes of applying Article 4.1b, even where a mark is identical to another with a highly distinctive character, it's still necessary to adduce evidence of similarity between the goods or services covered, in contrast to 4.4a, the double identity provision, which expressly refers to the situation. Sorry.
That's extended protection.
As extended protection, yes, that's what the friend says. So, in a confusion case where you're trying to allege mere similarity, you've got to show evidence, it's a common sense proposition. What they're saying there is, and actually we need to look at 23, in assessing the similarity, as the French and UK governments have pointed out, all the relevant factors should be taken into account, including the nature, end users, method of use, and whether they're in competition with each other or are complementary. I think that's been amended now. Is it end users that's been deleted and replaced with intended purpose? But the point is, there's a number of factors. You need to address them if you're going to allege similarity. We say that's our fortiori in relation to technical goods such as these. You've got to give the court some basis for saying these are similar to these because they're often supplied together, people think they come from the same source, and so on. That problem, it may be self-evident. You might have T-shirts and jumpers. You don't need to show similarity. They're not the same, but they're similar. But that's not this case. These are computer services for the telecommunications class compared to as a backup. You would expect some evidence, not just pointing at us, but simply saying objectively consumers in the market expect those goods or services to be provided from the same source. They have these similar purposes, similar uses, and so on. That simply has not been done. So we say that is probably the only point I wanted to show you from Canon. Oh yes, the other point is this. That's right. It's the interdependence principle, which is earlier on in the judgment. And I think that's a very important point in this case because 17, I'm reminded, a global assessment of the likelihood of confusion implies some interdependence between relevant factors, and in particular a similarity between the trademarks and between these goods and services. Accordingly, a lesser degree of similarity between the goods or services may be offset by a greater degree of similarity between the marks. Now, it does sound a bit formulaic, but what I think they're, if I could put it this way, what they're saying is, assume something doesn't vary. The sign is the same. It's not identical, but it's similar. Actually, in this case, Sky versus Skykick. Assume that. When you're assessing likelihood of confusion, it's never going to be double identity case because the signs are not the same. So it's a likelihood of confusion case. When you move one of the factors, one of the variables, namely the goods, the likelihood of confusion is going to be less the more you move away. That's what they're saying. That's the interdependence. And that is why we say, in this case, the judge approached this case on the basis that if there was identical goods and services, there was infringement, not similarity. That was not enough. And I'll show you that that was his finding, right up until the form of order judgment. So I can't rely on that as a procedural objection, but I say that the second, this is another reason to question the finding on computer services, because his approach at trial was to say things that are identical, taking account of the similarity between the marks, mere similarity, confusion. I'm not even going to talk about similarity of goods and similarity of marks. marks because obviously that's further away. Now, if I can just show you his main findings in his judgment, which is again core bundle tab 12. That's the judgment at paragraph 300. Overall assessment, he says. So he's been through all the factors. He's already decided some things are similar, some things are identical. And he says this in the overall assessment: the distinctive character of the marks and the identity of Skykick's goods and services, with some of those covered by the trademarks, are factors that support the existence of a likelihood of confusion. He doesn't say similarity, he says identity. Now, I accept that that is not an exhaustive exclusion of the similarity question, but in case there is any doubt, in his third judgment, which is in bundle, the third judgment at tab 16, paragraph 39, he refers to this paragraph and he says, I concluded at 302 that where Skykick's goods and services were identical to those covered by the trademarks, there was a likelihood of confusion. So we were proceeding on a very simple basis for 2.5 years. Email services were identical, but the judge was wrong. Nothing else had been held to be identical. And when computer services came in, it was held to be not only identical, but highly similar. And, not only identical, but also this new ground of high similarity. We say that finding is suspect. There's no basis for it, there's no reasoning, and it's wrong on construction. In other words, but as I said, we have a number of errors on email services and construction. I don't want to go through too much. I wanted to show you, just for your note, the AVNet read principle, which you'll find in the authorities at tab 4.
Just so I understand.
Yes.
I understand the canon approach to likelihood of confusion may require evidence.
May, not always.
But the prior question of similarity between two marks, does that require evidence?
Well, I think you've got to construe the earlier mark, first of all. If that's what
that's the job of the court.
That's the job of the court. That's not a matter for evidence. However, it then depends whether you're dealing with a registry case or an infringement case. But let's assume that keep it simple, you're dealing with a registry case where the goods are specified in terms. You can't just sort of go, oh, well, they're kind of similar, although some decisions do read a bit like that, I have to say. You're supposed to go through the factors and say, well, are these similar? What's the basis for this? I think we would put it no higher than this. You've got to have some basis. Sometimes it's self-evident. Sometimes it's evidence. Frequently you see this kind of evidence in the registry. Sunglasses are similar to T-shirts because many manufacturers make clothing, fashion, and they also make sunglasses. So that gives you an objective basis for the finding. Sunglasses are not similar to Porsche cars, even though Porsche might make sunglasses, because that's just a one-off. That just happens to be a party who've brand extended. That's not an objective basis for similarity. So it does need to be addressed, and the further they are away, the more it needs to be addressed, we'd say. We say in relation to AVNet, which is really the point I think I opened my submissions with today. If you look at this case, tab 4, the marks were advertising and promotional services, and the defendant provided internet services to the aviation industry. And he said, well, the claimant said, you're using your internet website to advertise, or rather your clients are. And this is a classic application of both canon and the sort of natural and ordinary meaning. First of all, the use and the function and the end users were not the same. But I rely particularly on the statement by Lord Justice Jacob, Mr. Justice Jacob in this, page 37, page 19 of the original report. The answer, I think, depends on how widely one construes this expression, advertising and promotional services. It's not an unimportant question, because definition of services, which I think covers 6 of the classifications, are inherently less precise than specifications of goods. The latter can be and generally are rather precise, such as boots and shoes. In my view, specifications for services should be scrutinised carefully, and they should not be given a wide construction covering a vast range of activities. They should be confined to the substance, as it were, the core of the possible meanings attributable to the rather general phrase. And he then construes that. He says the essence of advertising is not providing the promotional services in the way, the defendant is not providing advertising and promotional services in that way. They do no more than provide a place where their customers can put up what they like. So he's applying that to the facts. It was followed by the Court of Appeal by one Lord Justice Jacob giving the judgment. So I don't, other than quote from that, you'll see tab 6, where I think the facts of that case were employment agency services. And really, I say no more than the Court of Appeal agreed with that statement. Services specifications are inherently pretty fuzzy, and you've got to look at the core. That's not always easy, and it's often difficult when you might have a very broad, what's the core of telecommunications? Quite difficult because it covers so many things. But we say there is a unifying theme there, which is this, it's the act of communications at distance. That is part of it. But you've really got to look at the words of any particular goods or service and try and understand what they mean in commercial terms, in business terms. So another example from the canons of Lord Justice Jacob, but this time acting as counsel, is the toilet duck case. Do we have? I think this was given to my learned friend, I hope, overnight. Yeah. And I'll give 3 to my lords. Mr. Thorley and Mr. Jacob doing battle over toilet detergent, by the looks of things, a toilet duck, and there was the question in the case really was whether the Mr. Jacob's client's toilet duck was a detergent or not, and it was Whitford J who was judge, and essentially the position was that the claimants tried to call the evidence of an expert to talk about the chemical properties and cleaning properties of the of detergent and whether toilet duck was a detergent, and I think that was met with the defendant's expert report in the good old days. We had, if you look on page 154, a Professor Otterwill. I've been asked to give my opinion as to whether the lifeguard toilet duck product might have been recognised as a common soap or detergent. As a scientist, I would say it is neither. It contains some surfactant, primarily for dispensing dye and perfume, and not a detergent, and so on. And I think the judge preferred the evidence of Professor Otterwill so far as it went. But he then said this at the top of 155, trademarks are concerned with the practical, everyday realities of life. And the question is, would toilet duck be considered to be a detergent by those who buy and sell it? My view is quite clearly it would not. It's inconceivable that a retailer asking a wholesaler whether he'd got anything new in the detergent line would be offered toilet duck. If he were, his if you were offered this preparation, the comment would be likely to make is perhaps best left to the imagination. A husband asked to go out to the mini market or the supermarket to get some detergent is not, if he's in his right mind, going to come back and present his wife with the toilet duck. And he goes on to deal with the survey. So it applies to goods as well as services. It's a little, goods are a little more specific, but you still have to come up with some basic approach to construing this is. And what we say is that the judge made a number of interpretive errors. If you have my skeleton, the core bundle, I'll just race through the fine points on this if I can, as quick as I can. I know there's some authorities to get through. And you can, paragraph 61 of my skeleton behind tab 9. Essentially, we talk about the Reed Navnet case. We say that militates in our favour, and then we say even under the modern approach. So this whole furore, hullabaloo that was caused by the IP translator case about whether people had applied for marks correctly. The thing that came out of that was make sure that you apply for marks and certain, please. You know, we don't want any more of this nonsense, and that also militates in favour of the interpretation that we would put on the earlier marks, because we say two things. First of all, we say that after that translator, as part of the IP translator case, as part of the fallout, you can see in paragraph 66, the EU officers produced a further list of terms which would be bad, and one of those was related services. So you can't apply for a service and then say and associated services and other services and related services. And yet that was the construction that the judge put on it in his third judgment on email services, to which we object. We don't object to of. I think the judge says email services means of or related to services. We don't object to of, because that is the thing. But we do object to related services. They don't satisfy the clarity and precision principle. They don't identify the service. They don't tell you what it is. It's purely defined relationally. It could be anything. It just really is impossibly vague. And no doubt that is why it was able to bring in data migration. It happens to migrate, among other software or data, something that can send and receive email. Well, of course it does. It migrates everything.
We're dealing at this point with construction, aren't we?
Yes.
I'm not quite sure I see why the prohibition on related services helps on construction.
It isn't strictly relevant, because what it said, they didn't apply for related, but because the judge construed it as including related, he's notionally, it's as if they notionally applied for related. Had they expressly done that, they wouldn't have been able to.
But we're to assume at this stage that they've got it.
On the judge's construction.
On the judge's construction.
Yes.
So whether or not one ought to have it, they've got it.
Yes. It's no more than a reason.
To find it's an impermissible term doesn't seem to help on construction.
I'm not saying it's impermissible if the judge is right, but we say it's a reason why he was wrong. It was a reason why it was the wrong construction, because the vice is lack of certainty, relational but unidentified characteristic. So therefore, you shouldn't construe terms in that way. You should construe them in the opposite way, with precision, according to their nub or core. If that's right, then you don't bring in words like relational, a relational language. So the judgment I want to show you was the Altechnic case, because this is the significance of class heading or class to interpretation, and I hope I made myself clear that we don't really die in a ditch on class, number and heading. We say they're clear anyway, but to the extent that they're relevant, they provide a gloss on what these terms of construction mean. And it is suggested, I think, by my learned friend that somehow our technique is controversial because permission to appeal was granted by the Supreme Court House of Lords. In other words, that is not a submission that they can make. The judgment is binding and it hasn't been overturned. And we say it was jolly prescient in terms of it coming before IP Translator and saying, Lord Justice Mummery was doing no more than saying, look for anything that gives you clarity and precision. So not only is it not suspect as a matter of pure doctrine, but it is good and sensible principled decision, we would say, if anything. So if I can just show you our technique, that's in your first bundle of authorities, tab 5. There's one passage in it that is worth looking at. By way of background, my learned friend may well say, well, this was a case on its own facts, and he knows obviously a lot more about this case than I do. It was about amendment, and there were some complications to it. But we say that the judgment was not expressed in a way that confines its effect to its particular facts. And I can pick it up at paragraph 42 on page 49. The issue here was where you put, if you want to move valves from one class to another, does that change the meaning? Answer, yes, because valves are quite a generic term. You put them in one class, they mean something, and you put them in another class, they mean something else. Could do. The judge just said the result is not inconsistent with the approach.
Which paragraph did you say?
42 on page 49. The result is not inconsistent with the approach in the registry, nor the general practice of the office. I'm going to say that's still the approach. The office and the UK IPO do take account of class number when dealing with amendments to an application. In my judgment, the registrar is entitled to treat the class number as relevant to the interpretation of the scope of the application, for example, in the case of an ambiguity in the list of the specification of goods. And this is the bit, I think, which is most helpful. The application is a considered statement of the applicant, which on ordinary principles of the construction of documents has to be read as a whole to determine its meaning and effect. The fact that the internationally agreed NIS classification system has been designed to serve exclusively administrative purposes does not mean that the selection by the applicant of one or more class numbers has to be totally ignored in deciding as a matter of the construction of the application what the application is for and whether it can be properly amended. And then he deals with specific difficult cases where someone has mentioned all goods or goods in this class within the text and so on. We don't need to get into those points, but we say that position has been absolutely, that chimes very much with the current approach of coming up with clear and certain specifications and making registers more transparent. Section 60 of the Trademarks Act, my learned friend said, was effectively an answer to this. We disagree with that. If you take, where's section 60 of the yeah, so it's the Trademarks Act, my lords, yes. Tab 55. These are it's only extracts from the Trademarks Act, and tab 55. That's 60A, is the relevant provision. So it is page
686.
Thank you very much. 686. And it's similarity of goods and services, 60A. For the purposes of this Act, goods or services, A, are not to be regarded as being similar to each other on the ground that they appear in the same class under the NIS classification. B, are not regarded as being dissimilar from each other on the ground that they appear in different classes under the NIS classification. We just make 2 points on that. First of all, it isn't clear that this is talking about the comparison of goods in the real world versus specifications, because it's talking about appearing in the same class. It does seem to be about what happens in the registry. You can't say, because it's in 9 and that's in 18, they must be different. If the later mark is applied for in class 18, we haven't applied for a mark here that's under attack. This isn't an opposition. We're being injuncted in the real world based on a registered trademark. So I'm not sure it applies, but for what it is worth, what we would say is this. All this is saying is that is not determinative. It doesn't mean, or that is not the factor that causes similarity. It does not exclude, I think the question put by Lord Justice Floyd, whether it can be relevant to construction of what a term may be. And in particular, in an infringement case, determining what that term covers for the purposes of infringement. So we say that only goes so far. Sorry. The pathway case.
Can I take you back a bit?
Sorry, yes, to this. Yeah, I'm going to.
No, not to that.
Oh, sorry.
You referred to the IP translator case.
Yes.
And my understanding was that was only a prospective ruling and had no impact on pre-existing registrations.
It was odd. It was odd because.
So to what extent can anything that the Court of Justice say in that case be of relevance to us construing? I think all these marks were registered before the IP translator case.
Yes.
So what benefit can we get from that case when we're trying to construe the previous
I think that
marks?
I seem to recall this point did come up at trial in some way. That the IP translator case, which I know my learned friend referred to the ECJ as sitting as the appointed person, had two parts to it. There was the part about masking terms. When you adopted the class heading, you were building services and you got the pest extermination. It's not immediately clear that that's a building service, or condoms and surgical instruments. So you got things that were not within the term. There was that aspect of, does a class heading automatically entail all coverage? That was temporal, and that was dealt with by way of legislation allowing parties to nominate which way their marks were intended to have been applied for. The other provision in there, or the other principle in there was a bit different about clarity and precision. And I would suggest that that is of general application. It has always been the law that you have to, European Union law and UK law, that you've always had to arrive at a form of words with a reasonable precision to allow the mark to be considered on grounds of distinctiveness, earlier rights, whatever it is. So I don't quite know whether that's the answer to my lord's question.
Well, if that is the case, that is the answer. But where do we find the statement which Mr. Hobbs clearly made to us? That
yes.
The ruling in IP translator is only prospective.
Yeah.
I had a quick look through the judgment. I couldn't see it in the judgment, which is where you would normally expect to find it.
So I reminded my learned junior that this point did come up, I recollected, at trial. And we said at paragraph 60, I'll just read it out, that we say in Skykick's submission, neither of the more recent judgments of the CJEU that temporarily limit IP translator shed any light on the issue of clarity or certainty as a general principle, because we say those were about the class heading covers all aspect, and there was nothing in general when the Court of Justice, for example, in Seekman, decided that signs have to be clear, certain, intelligible, and so on. That wasn't time limited.
No, most judgments of the CJEU, as I understand it, are like English judgments.
Yes,
they declare what
exactly
the law
so.
has always been.
Yes.
But there is this particular
Exactly.
jurisprudence in Europe which enables the CJEU to limit its ruling so that it only applies prospectively.
Exactly so.
But
And it has to be a very restrictive approach to that sort of thing.
well, it depends on what they say.
Well, in Brand
So
Concern-
where do they say it? Because
Right.
I don't think it sounds from what you've just read. They didn't say it
No,
in IP translator itself. They said it subsequently.
they did.
Yeah,
They did it in
they
two
did.
cases subsequently that are mentioned in my skeleton. One is the skeleton below, which was Brand Concern. I will. Brand Concern against EU IPO, and they talked about whether the class heading language covers all is prospective, and similarly in EU IPO and Cactus, they also only discussed the class heading covers all aspect being retroactive. So they never expressly said that the clarity and precision principle was not retroactive. That by virtue of silence, we say it's there. But actually, there's another point of my learned junior's intent that I show you, that in any event, each of the Sky marks was registered after 19th of June 2012, which was the date of IP Translator. And so each was still an application at the time, which under the Cactus case meant that it did apply. So we argued that at trial. I'd forgotten.
I thought they had all been applied. They'd all been applied for before 2012.
But this was an application, though. So it was not granted.
They weren't granted.
It wasn't granted until after IP Translator. That's
Would you mind if I answered your lordship's question on that?
I think I should give you just, happy for my friend to do so. I just wanted to give you, I'd forgotten this is in our unagreed bundle, Sky's unagreed bundle, tab 15, and we refer to it at page 213, and we talk about those two cases.
Is that all right? Yes. Do you mind? They didn't say in IP Translator that it was prospective only. They didn't say. And that was contrary to what the usual practice of the Court of Justice is, which is to say explicitly that they confine the effects temporarily to the future. IP Translator came back to England. I was the referring tribunal. I had to write a judgment on this point. And when I wrote a judgment when it came back, I assumed, exactly as my lord has just put, that it operated in the same way as an English judgment would, which is to say it declared the law as it always was. What then happened is that in a line of cases that followed, and it was like a little movement here and a little movement there, they established a position which became clear through a process of evolution in the case law that the effect of the judgment was indeed only prospective. It's nothing to do with the date of registration, it's to do with the date of the application. Now, the simplest and clearest place to look for the ruling on that is in the CJEU judgment in our case. It's paragraph 61 of that judgment that we got on reference here, where they have a separate paragraph on this point. In any event, it must be added. And you'll see they cite brand concern, which my friend just mentioned. There's Cactus. But what they say is provided clarifications only on the requirements relating to new EU trademark registration applications. Because you can get a registration date which is well after the date of the application. Now that is...
It is actually ambiguous in the sentence, isn't it? Because you get reference to trademark registration applications.
Yes.
And that doesn't concern trademarks that were already registered.
It is ambiguous. It is ambiguous, but the case law they cite is not ambiguous.
Yeah.
And if you want a fuller answer to your question, the Herschel Smith Professor of Law in the University of Cambridge has written an article, a piece on this very point. May I ask you, in the Authorities Bundle, tab 3, to turn behind tab 64. This is a book with many authors. Professor Lionel Bentley wrote this chapter. If I take you to the heading on stamped page 779, where the sidelining starts, you have prospective effect only. If you turn the page to 780, we've sidelined more, but he explains why in a way which I would believe would satisfy my Lord's inquiry. In intellectual property law, the most prominent prospective ruling was in the IP Translator case. and he explains how, through the subsequent case law, which is referenced in paragraph 61, which my lords found somewhat ambiguous, he explains how the case law evolved in the way in which it did. And I could, but I won't, because I'm intervening and I'm grateful for the opportunity. I could cite plenty of other authority. In fact, it's in our skeleton. Our skeleton identifies all the cases in which they continue to interpret applications made before IP Translator on the basis of legitimate expectation and legal certainty, on the basis of the practice statement number 4 of 2003, which led to all those applications in the first place.
On the registration application point, I don't know how far it will prove to matter, but I see at page 783
of Bentley's article.
Of the Bentley article.
Yeah.
He says in the third full paragraph on that page that in brand concern, the CJEU interpreted IP Translator as only applying in relation to new applications.
Yeah.
And so he's citing brand concern.
He is. And Cactus he goes on to. There's a similar issue which arose in relation to a case called Practica. Practica preceded. Practica, I referred to Practica, and it's part of the reasons I made an order for reference in IP Translator. The same thing has been done with Practica, which laid down requirements which they've not applied backwards. And in the bundle, there's a case called Tully Allen, Burlington. We mention it quite a few times in our, well, more than once in our skeleton. And they again, in Tully Allen, make it clear that the effect of the ruling is prospective. It doesn't apply to applications made before the IP Translator date or the Practica test date. So you have to unravel it. It would have been better if they'd actually said explicitly. I say with a certain amount of regret, having assumed that they'd not done it prospectively and written a decision to that effect. But anyway, my lord, the position is solid and clear. Application date before 2012 is not caught by the IP Translator ruling.
Thank you. I'm sorry, Mr. Manager, it's quite a long answer to
yes, that was
question.
quite, and I'm grateful for my learned friend for the detailed guidance, although I have to say I'm not absolutely clear still. I think perhaps like Lord Justice Newey about whether it covers applications of registration, whether it covers that part of IP Translator, because that was not the part that was in issue about whether umbrella terms cover everything. But
if it's important, we'll have to look
it's
at
not important.
the
That was
brand
going to be my
concern
suggestion.
and see precisely the terms in which they're said, because the CJEU tends to use words with precision.
We say,
but if it's not important, then it's not important.
it's not important. Email services, in fact, we say to some extent the opposite in relation to email services. It's quite clear. It's not us on construction. And we say in relation to computer services, we don't, obviously we're not running any more IP Translator point. One of the reasons why we say it should have been a ground of invalidity was this very problem. You have all this huge mammoth number of marks that are sitting on the register, class heading covers them all, and poor old Joe Public doesn't know which ones are prospective, which ones are retrospective, and so on. Should be able to invalidate these terms if they're bad. But anyway, we lost on that, and that's the end of it. So the pathway case, I'll probably just conclude that very quickly before lunch, or should I? I don't know if my lords wanted to, but I need about 5 minutes on it.
According to my watch, you've still got 5 minutes.
Great. So pathway is in bundle of authorities, the second one behind tab 30. This is a judgment. 30, so it's the last one, is it, in this?
Authorities to.
Got it, thanks. This is one of the final judgments of the late Mr. Justice Henry Carr, and it opens with a memorable paragraph that I suspect will be, it refers to this case and may be referred to years to come. Unless familiar with the law of registered trademarks, you might think that it's relatively straightforward. Regrettably, you would be wrong. As illustrated by the recent judgment of Arnold LJ in Skykick, trademark litigation can raise multiple legal issues of Byzantine complexity. In comparison with the Sky case, this judgment is a minnow, the less challenging issues which require careful consideration. And the thing about this case was it is really a tour de force in terms of this issue about class numbers and the significance of them. I would commend to my lords, but in particular the passages picking it up at 365, the sideline passages. He deals with all of the competing considerations. The objections by Arnold J in the Omega cases about whether it's legitimate to take into account class headings language. He considers the scope and effect of our technique, both on the basis that perhaps it was wrongly decided or that it can be restricted to its facts. And he considers all of the arguments that have been canvassed before you. And he comes to the view, in essence, there are pages of analysis here that I'm not going to take you through, but he comes to the view, essentially, that it can be relevant in the right kind of case, and it isn't to be airbrushed out. And in paragraph 100, he notes that it is still adopted and used by the EU IPO and UK IPO, and it, although that's not determinative, as he notes in 102, it suggests that class number, the manuals in those jurisdictions suggest that class number should always be taken into account together with the natural and ordinary meaning. We don't necessarily go that far, but we say that it is a helpful guide and a gloss in cases of doubt, or to imbue a mark with a bit more meaning if it's a bit too abstract and a bit strangely expressed, a bit like the computer services one. So, my lords, that really is where we
The
get
punchline is paragraph 79.
Yes, exactly. It's appropriate to use it as an aid to interpretation where there's a lack of clarity and precision. This applies to granted registrations as well as to applications. I think he took the view that I submitted to him, perhaps wrongly in light of the points my learned friend has been saying, but I think I submitted that clarity and precision was always a good thing and always was a jolly good thing, and it hadn't been invented by IP Translator, merely acknowledged. So I was going to get into the explanatory note very quickly after lunch. I'm almost complete.
So this is a convenient moment, is it?
Yes,
By my watch, it's 5:21. I don't know what anybody else's timepieces say, but on that basis, I thought we ought to start again at 5:22.
yes.
We have a clock that's magically...
Oh, we've got a clock today. Yes, I was looking there. I've been looking there then. Yes.
Say 5:22.
Court rise. About to stop the live stream, but for 90 seconds anything you say will be broadcast.